Welcome back. You're watching HFO TV. HFO TV is co-sponsored by J.R. Johnson LLC, specialists in multifamily restoration and repair work. Gantry Incorporated, the nation's largest independent mortgage banking firm.
And then we brought up the bill that passed regarding units that had some subsidized units.
Right.
And I think that was Bill 3042.
Right.
Maybe you can shine a little light on that one, because again, that one was didn't get as much publicity. Because I think it was kind of in the world of a lot of the nonprofits were kind of talking about it, but it really wasn't out there. We're going to get picked up by the press or anything like that. But kind of talk a little bit about that one.
Right. Well, normally, if you have a tax credit deal, you sign a rent regulatory agreement, and it's a contract with the state. And you also have, as part of that rent regulatory agreement, an additional extended use period after the initial 15-year period is up. They're normally 15-year periods. And once that extended use period, which is contractual, expires, you're then allowed to raise rents to market. And that's the deal. This bill says just 1 minute. There's another 3 years on top of that. And the 3 years on top of that are rent increases that can only be issued by permission from OHCS. So you need to seek OHCS's permission for any rent increase, and they will routinely give you 5% increases. But my understanding is that they do not give increases in excess of 5%.
So your regulatory agreement's over, like you said when you developed the deal, and I'm going to do this, and we're going to do it. We're going to bring affordable housing to this market, and part of that is we get some benefit. And now it's 15 years typically, and I have a little bit of a tail. Now they're saying, wait a minute, we're going to add more to this.
Yeah. Now, I think that impairs the obligation of the contract, and
yes.
There have been a lot of cases that took a look at the eviction moratoriums. In Oregon, Judge Steinman ruled in the Farud case that the moratoriums, in fact, did impair the obligations of contracts, but was able to seize on some case law that said in the time of an emergency, like COVID, like the pandemic, there could be exceptions. Here, there's no COVID exception. There's no pandemic. There's just people who, can't afford, or so they say, to pay the rent. And I think that those portions of this brand new law are certainly vulnerable to.
And is that going to go into effect right away? Is it another? It
goes into effect right away. And so I know that More Housing Now and a few other organizations are actively considering organizing owners of LIHTC properties to explore whether we ought to file a lawsuit to overturn that one. That would be a good instance of how you can use a lawsuit for good, just like we did with the screening fees.
And we had, I understand, we talked to the state and OHCS about kind of why they were behind this, and the idea being you've got buildings coming out of these programs and they want to keep them. And as we talked with them, I mean, they know it's public record. They know when the buildings are going to come out. I mean, you've got to give tenants a notice 3 years ahead of time. Right. They also, the obligation, there's not an obligation we have to do it, but they've got time to get their funds ready from the state, but they just are so disjointed that, they just keep putting that burden back on the person that provided the housing. It doesn't make a lot of sense.
Look, all of these bills are just efforts to transfer responsibility from the people for whom it belongs, which is the state, incompetently managing their programs, to owners.
Yes, it just makes that just made no sense. I mean, trying to talk with them about it, they tried to bring a couple examples, and I was saying, wait a minute, you knew this building was coming out 3 years ago.
Right.
I mean, and then we're not even talking on the legal side of it, that how do you change a contract? I mean, we had a contract when this person developed the project and brought housing into the market, affordable housing, and you just, at the end of the contract, we're going to change it. That just, yeah.
And see, one of the other problems with all of this legislation is, they come back, the advocates say, well, look, you can't raise rent more than 7% plus CPI or 10%. They say,
right.
You don't routinely raise rent by more than 10% anyway. What do you care? Well, I can tell you what we care. We care for the message it sends to everyone else across the country, which is the Oregon legislature will not stop. So, if you're going to build new construction, or if you're going to buy up other construction, you're going to be subject to rent control at some point in time, unless we totally change our politics. And if that's the case, and you have a chance to build in Idaho or in Nevada or somewhere else, or Oregon, where are you going to build? See, I think this just totally, same with IZ rules. Inclusionary zoning makes it just more difficult to build affordable housing.
Yep.
And if it doesn't pencil out, it isn't going to be built, which means that the supply is going to remain fairly stagnant. The demand is going to increase and the rents are going to go up. And so their solution is, well, then we need rent control. Well, if they have rent control, they'll turn this into a New York City where some of the housing is affordable, but the rest of it is out of sight. Yeah.
Well, I always say, if you want to limit rent raises, then make supply there. Because again, we don't set the market on rents. It has to be a supply and demand. If you're worried about rent increases, then don't put policies in that are going to restrict supply. Put policies in that encourage supply, and trust me, your rents aren't going to go up as much because they'll be oversupply. So that's how, developers work. They're going to oversupply.
So here's one more thing they did that's very important to know about. And the owners, you need to talk to the lawyers who do your FED work for you.
Okay.
House Bill 2001, which passed already and is already in effect, changed the FED laws to require additional notices. So if your forms aren't up to speed, make sure they are, because if you don't give out all the forms and you have an FED, that could be grounds for dismissal.
And John, this is statewide, right?
Statewide.
This one's state.
Now,
okay.
Dismissal if a landlord has not reasonably participated in a rental assistance program. Now, I have no idea what that really means. Does it mean if a housing group offers rent assistance, but it'll be 3 months from now? Is that reasonable assistance?
Right.
Nobody really knows quite what that means. But if you don't reasonably participate in a rental assistance program, your FED can be dismissed. And it can be dismissed if the tenant shows up with the amount of the rent. And that means that you don't get your attorney's fees, which means that going through this FED process is no longer going to be as expeditious as it was designed to be, and it could cost you money. And so many lawyers are thinking, well, maybe we should just have a regular lawsuit and sue the tenants on the lease. At least then we can end up with a judgment. And if they owe us money, we can ultimately get paid and we can sue for ejectment. And so they're going to be ultimately have to be dispossessed of the property anyway. But I don't know.
Okay, so there may be another track to go, but yeah, we'll make the dig in deeper on that one.
So that's why I'm saying, they're trying to go 10 steps forward and then we pull them 5 steps back. But with this legislature and our governor, we're still losing ground.
Yes. And do you feel that you travel, is our legislature further along in doing this than, say, state of Washington or California?
Well,
or is it different components?
The Oregon legislature certainly took the lead, first in the nation, on statewide rent control.
Yeah.
I think the key is to make sure that we don't end up with vacancy control.
Yeah, the unit restriction's a little scary. That got slipped in there at the end. That's your end. Yes, as we've talked about, once you let them in, it's going to be hard to get them out.
Yeah.
So we need to be very vigilant. So, well, I know we're taking your time, so thank you for doing this. I think we'll definitely be in touch. We're definitely going to be in touch on the Bill 3042 because, again, we've already talked to some owners. It was a kind of an eye-opening for them that, wait a minute, my regulatory agreement is extended.
Yeah.
That wasn't the deal. We need to talk further. So I think there's going to be discussions about that. And again, we need to just keep owners informed and get them engaged because, as you said, it's 10 steps forward, a couple steps back. But we got to keep. You can't just wait and then try to deal with it after the fact. It's going to be too late.
Right.
So thank you again. Enjoy DC. We'll look forward to hearing your stories when you get back, and we'll see you again next time on HFO TV.
Right.
Thank you.
Thanks,
Johnny.
Our entire office specializes in multifamily real estate, making HFO the largest multifamily brokerage in the Pacific Northwest. Your success is our passion. Build your legacy with HFO. Call 503-241-5541 or visit our website at hfore.com for more information.